Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Kristina Perry Alexander crosses the county line to tell us about an alcohol distribution agreement. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown from Law Insider. I'm Mike Whalen. We are here with my friend Kristina Perry Alexander. Kristina, how are you today?
I'm great. Thanks for having me, Mike.
I appreciate you being here because we're going to get into territory that is unknown to me. As the guy in this conversation went to BYU, we're going to have a whole conversation about alcohol. I could tell you about some home issues. Well, you know what? I'm going to leave that for a later piece of this conversation. But I am ignorant as to a bunch of the rules around alcohol. I feel like I'm walking into the world of Footloose, where you had to go to another county to be able to dance / get alcohol. This is me in this conversation. We're going to talk about a document. Let me show it to the folks at home. This is called a distribution agreement. Kristina, what the heck is this thing that we're talking about?
So this is a contract for the distribution of beverages, and from how it's written, it looks to cover beer as well. So basically, a beer or a beverage producer would enter into one of these contracts with a wholesaler, a beverage wholesaler, who would then sell to other wholesalers or retailers, who then sells it to the public through the three-tier system. That's what we call the distribution system for alcohol. And there are a couple of issues with this contract that we'll talk about in a few minutes.
Yeah, and before we dig into it, tell us about you. What's your background? What brings you to documents like this?
Sure. Well, my first introduction to these types of documents was as an administrative law judge with the Virginia Department of Alcoholic Beverage Control. The Virginia ABC Act has what are called Virginia beer franchise laws, and those laws govern the relationship between beverage producers and beverage distributors. So this is the type of contract that I would have been adjudicating. If there was a dispute between the parties, it would have come before me on a 3-judge panel.
Okay, so this one, I'm going to start digging into it. And when I say I have to cross county lines to be able to dance, I'm being literal. I live in Kansas right now, and for us to be able to, there are different rules when you're at a grocery store in Kansas versus when you're at a grocery store in Missouri, and trying to figure out if I want to get wine to even cook a dang pasta sauce, it's a totally different relationship if I'm here versus there. And I bring that up because we need to jump down to the territory. If I look in definitions in this agreement, one of the terms that is defined is in 1C. It's the term territory. It means the geographical area specified on Schedule A. And if I scroll all the way down to Schedule A, it says, this is the longest exhibit I've ever seen. It says Texas, California. That's it. So tell me about territory. This seems, legit. It seems like a very important deal that they're just kind of taking in passing. Tell me about this territory section. Do you like the way they've worded this?
Well, so you brought up an interesting point. The alcohol laws, just over state lines can be very different. And that is something that's not just in the Midwest, not just in California and Texas, it's across the United States. So the first, big issue that I have with this contract is the fact that it lists 2 different states that have very drastically different alcohol laws, especially when it comes to beer. So Texas is one of those states that has beer franchise laws, and California, at least so far, is one that does not. And so you're going to have a lot of provisions in this contract that are going to be perhaps enforceable in one jurisdiction, but not in another. And so that creates an issue sort of right off the top.
Yeah, speaking of it, okay, so we've got Texas and we've got California. And if I jump down to 15F under miscellaneous provisions, which this doesn't seem very miscellaneous when we're talking about all this state-specific law, but if you look down at 15F, there's a section governing law, and it says all questions pertaining to the validity, construction, execution, and performance of this agreement shall be construed and governed in accordance with the laws of the state of New York, according to Section 55C, without giving effect to the conflicts or choice of law provisions thereof. What do you think? We've thrown in another state. How are we feeling about 15F referring to New York as the governing law?
Yeah, so if you're talking about non-alcoholic beverages, The New York governing law, the New York UCC, which governs this contract, at least on the paper, might be fine. But when you're talking about alcoholic beverages, pretty much across the board, the territory and the governing law for the contract is going to have to match the state where the alcohol is being sold at retail, because that's where the alcohol enters the marketplace, where it becomes available to consumers, and that's where the law applies. So this contract probably is going to be unenforceable for both beer sold in California and beer sold in Texas, because New York law simply wouldn't apply.
I want you to take me back before we dig into the next section and talk to me about the relationship. If I'm understanding correctly, this is an agreement as between a manufacturer of spirits of some kind and a distributor, a company who's putting it on trucks and taking it to the stores. Why that relationship? Does the distributor have the relationships with the local stores, and the manufacturer of the alcohol is just trying to focus on that? Why do we have this relationship?
Well, at least for beer, wine, and spirits, we have this relationship because it's legally mandated. In most states, a producer of alcohol cannot sell directly to a retailer because of prohibitions that are included in the three-tier system. So this contract actually is between two New York entities, it seems, and you may be able to use an intermediate wholesaler to sell, but ultimately, before the alcohol is going to be able to get to a retailer, it's going to have to pass through an in-state wholesaler. And so, this may not be the only contract for distribution for these beverages. The wholesaler may have to enter into another contract with an in-state distributor in order to get those beverages in-state. And so, that it's not just necessarily a choice between the parties in this case. In most states, most territories, it's going to be a requirement that you sell through a wholesaler.
This is relevant because when I jump down to 2, it notes the recognized territory. I'm going to read a bit from this. Company hereby acknowledges distributor as the exclusive distributor of products within the territory, Schedule A, that very long schedule, with the right to redistribute same to various independent operators for further distribution within the territory. So to your point, they might be using somebody else in these territories. Accordingly, the company shall and can directly or indirectly sell products to any person located within the territory or authorize or permit any other person to do so, and it is distributor's responsibility to service that person under the terms set forth by the company. I don't understand that. So who is able to sell to whom, according to this agreement?
So it's I'm not surprised. It's a little bit of a word salad there in that provision. But one thing that it does is it retains the right for the producer of the beverages to directly sell them. This is most important when you're talking about e-commerce. I did do a little bit of research into this beverage producer. I couldn't find any beer that they were producing, but I believe they had a horchata that you could order, non-alcoholic, over the internet. And that's probably, so that they can have one of those customer-facing user experiences where you can order e-commerce. It may be fulfilled directly from the manufacturer. It may be fulfilled from a third-party wholesaler, but this kind of provision, which I'll say is not a typical one that you would see in an alcohol distribution contract. It is one that is smart to contain in all types of beverage distribution contracts, because states are starting to create more exceptions for direct-to-consumer sales in wine, certainly, but also in beer and spirits.
I want to ask about additional products here in a minute. Before I do, make that make sense to me, because it feels like when you're this specific state by state, when you're this specific by type of beverage, whether it's non-alcoholic or beer or wine or spirits, should a contract do what this one is doing, where it's sort of one big bucket of all these decisions for multiple states, for multiple types of beverages? Or do you normally see, okay, here's a distribution agreement for this type of drink in this type of area? Why is do you see the lack of specificity in this contract as problematic?
I do, because there could be unintended consequences. A company could have, no idea that 10 years down the road it's going to do a beverage extension into a new type of beverage. Seltzer has just exploded over the past 10 years, or really just 5 years. Um, and many beverage producers didn't know that they might be including seltzer. Now, that's also a beverage that, depending on the state, could be considered beer, could be considered wine, could be considered something else entirely. And so, you definitely want to make sure that you are making these contracts govern only very specific beverages. Be careful about giving a distributor a right to a brand extension or a new product, because that could become a new product. That could mean a new product of a competitor that was acquired under the same brand or something. I've seen, very strange situations arise, especially in the beer context with all the consolidation going on. And then you have distributors fighting over the rights for these new brands.
I want to jump then to 13. To this concept of additional products, let me read this. It says, in the event companies shall desire to sell other beer or beverage products, the new products, within the territory, distributors shall first be offered in writing the exclusive right to distribute the new products on substantially the same terms and conditions of this agreement. Distributor will then have 30 days from the receipt of the notice to notify the company in writing of its election whether to distribute the new products or not. What do you think of this section and what it's doing for these potential additional products?
Well, this is great for the distributor if they can get this type of a provision in a contract. Certainly, having the right to distribute a new brand or a new product might be great for a distributor who can handle the bandwidth of a new product. But this kind of provision could also be unenforceable, because in states that have those beer franchise and wine franchise laws, they also have, some states have spirits franchise laws. The laws can give an automatic right to a new brand or a brand extension to an in-state distributor that's already got a contract. So, whether or not the producer is trying to negotiate, just a little bit of a right of first refusal, it really can end up being, a right that they didn't intend to grant just by virtue of the state they've decided to do business in.
All right, last section, termination. This is in 8A, subject to paragraph 9, talking about post-termination obligations. Companies shall have the right to terminate this agreement in accordance with New York State Law 55C for any reason or cause with no less than a 2-week written notice. There's a lot of entanglement in this agreement. I mean, you got right of first refusal with the distributor. A 2-week notice for any cause seems like a pretty drastic termination. What do you think about Section 8?
Well, in some states, and especially in Texas, I believe, this is just straight up unenforceable. Many state distribution laws and franchise laws in particular can make it so that a unilateral cancellation or even a non-renewal of a contract for a set term, it turns it into a perpetual contract that can only be terminated for cause, and sometimes only for specified causes in the statute. So, one brewer, I think I recall, describing these types of laws as a marriage with no possibility of divorce. So counsel, especially for producers, needs to be very cautious about entering into new markets to know whether or not these laws exist in those markets, because entering a contract for a 5-year term with the option to not renew could just simply be unenforceable.
I appreciate that. I, again, feel a bit like I'm crossing the state line to dance on Footloose, which, by the way, I think they made a remake of Footloose. So for the younger people, there's probably 2 beautiful people, but it will never be Kevin Bacon. But I feel like that person crossing the state lines. And I think for the people who are watching the show and listening to the show, they're doing the same thing, right? A lot of our contract draft, this is a bit of an unusual context, right? This is not a context that a lot of the practitioners that are watching will be dealing with. How do you think about, as a practitioner, that idea of when have I gone past the state line? When have I gone too far, and how do I seek the right kind of help? You have given good advice on how to deal with documents like this and some red flags to look out for. But I feel like there's some question of when is it too much? When can I just sit and play around the edges of these things? When does it go too far? When you're doing agreements like this, are you looking for specific state counsel every time you're stretching out? Like, tell me about your sort of mentality when you get past the state lines, as it were.
Well, and you've hit on a very interesting issue with the alcohol law practice sort of bar, as I will, and I use that term loosely because, there's not a lot of people in a lot of states who do this law. And so, as you're saying, as you suggested, you are probably looking for specific state counsel or someone who has experience across the spectrum. I represented producer parties and negotiated contracts in 30 states, but that's because I have expertise in this area of law. But there were plenty of territories where I did reach out to counsel in the state who had experience with those laws. And even with my expertise, there were some states where I had to go in and say, is this really what I think it says? And there's just no substitute for that, but there just are not a lot of people left doing this law. It's a little pale, stale, and male, if I could describe it that way. So we really do need a little bit of a rejuvenation and interest in this area of law, especially because so many of these laws are being used as a blueprint for cannabis regulation in many states. So the practice area does translate. Now, I'm hoping that states don't start adopting all these franchise laws for cannabis regulation or cannabis distribution, but that's an issue for the future.
Yeah, it's so interesting because a lot of this is so archaic, honestly. I mean, this is like from a period from the 1930s or something that we're holding on to it, and now just to have a simple system, we're going to go apply it to cannabis. That's super interesting, and I appreciate the call to the bar. You guys must have a lot of bar jokes. I'm not going to, my contribution is dad jokes, but I'm not going to do any more, I promise. All right, Kristina, thank you. Thank you for that invitation to come and join this interesting area. And again, specifically, if you're thinking about cannabis law, there's an interesting overlap there. For people who want to learn more about your practice and maybe join in this fight that you're doing, what's the best way to reach out to you, Kristina?
Yeah, well, you can reach out to me through my website, ryeandreason.com. There's also information there about a book I'm writing on alcohol law called Toward Liquor Balance.
Got it. We will make sure that information is included over at the blog at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show and beat up contracts as we are wont to do, just email me. I'm at community@lawinsider.com. Thank you again, Kristina. We'll see you guys next time.
Thank you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.